my name is Charlie Morris. I'm the Chief Investment Officer of Woodsford Litigation Funding, which is headquartered in London, but has offices in the US and in Singapore as well. The litigation funding industry is constantly evolving. In the past, particularly in common law jurisdictions, it has been prevented by the archaic doctrines of champty and maintenance. Maintenance is where a third party supports a litigation, and champty is an aggravated form of maintenance where that third party takes a share of the proceeds. In recent times, governments across the world have realised the very many benefits of litigation funding and have started to change the law to erode the concepts of champty and maintenance. Very recently, Singapore and Hong Kong have both changed their law to permit funding for arbitration, and their courts have also made it clear that funding is permitted for insolvency claims as well. I fully expect the gradual erosion of the doctrines of champty and maintenance to continue apace, and for litigation funding to become even more widespread across the globe than it is now. Litigation funding has many benefits for claimants. For example, impecunious claimants often face the significant challenge of having to post security for costs at a very early stage in their proceeding, and a litigation funder can help with this. The ways in which it can do so are to, for example, make a payment into court on behalf of the claimant, or provide the claimant with a contractual indemnity against adverse costs, or use its very significant connections with the adverse costs insurance market to obtain a deed of indemnity from an A-rated insurer. Another way in which litigation funding can help claimants is in the context of settlement, and there are two key messages that a claimant can telegraph to a defendant in the context of settlement when it's funded by a third-party funder. One is that it's now fully funded and able to bring its claim through to conclusion. The second key message that a funded party can convey to a defendant when it's taken funding from a professional funder like Woodsford is that an objective third party has carried out thorough due diligence into the claim and independently concluded that it's a claim that's very likely to succeed. Professional funders are often staffed by litigation lawyers and arbitration practitioners, and so understand claims very well, and they often have investment committees that are made up of judges or former judges and arbitrators, and therefore sending that message to the defendant that their claim is likely to succeed and result in a recovery is often, in our experience, very likely to result in a higher settlement offer being made. The litigation funding industry is thriving and growing at a rapid rate. Barely a week passes at the moment without litigation funding hitting the press for one reason or another. Either new funders are entering the market, or existing funders are trying to list on stock exchanges, or even raise capital. So, for example, Woodsford announced that it had raised $75 million recently. With more funders in the market and more money, there is of course more competition between litigation funders. It is important to be mindful of the potential for a fallow period. We are, after all, a financial industry like any other.